Before I read my keynote address, if there's anything in the address that appears repetitive, I will say that I don't know whether those who gave goodwill messages before me had a peek at my address. So let's just say that mine may be a bit more in detail, but definitely we all have the same opinion on the direction that the legal profession needs to go. It is both a privilege and a profound honor to join you at this year's Law Week of the Nigerian Bar Association Lagos branch. I sincerely thank the chairman, the executive committee, and the entire branch for this gracious invitation. I must also commend your tenacity, because I have been invited to this event a couple of times and official duties would not permit. But this time they were very, very tenacious. I also commend the branch for choosing a theme that speaks not merely to the future of legal practice, but the future of justice itself. It invites us to look beyond technological excitement and reflect on the constitutional, ethical, and institutional questions that accompany every major transformation of society. I do not stand before you as one whose understanding of the legal profession has been shaped solely by service on the appellate bench. Like many of you, my professional journey began in private legal practice, where I came to appreciate that behind every brief, every client, every legal dispute lies a human story, and that the law is ultimately a profession of service. From private practice, I was privileged to serve as a magistrate, striving to ensure that justice remained accessible to those who came before the courts with little more than their faith in the rule of law. I subsequently served as a judge of the High Court of Lagos State, presiding over disputes that tested every dimension of our legal system, from commercial transactions and constitutional questions to criminal trials and family disputes. I also presided over tribunals entrusted with determining matters involving the gravest offenses known to our criminal law, where every decision carried profound consequences for the lives of those who stood before the court. I will also say that my introduction to technology started as a judge of the High Court. First, struggling to learn how to type, because in my time when we were in school, that wasn't one of the subjects we were taught. And I found that whenever I delivered judgments, in those days we delivered judgments in longhand. And after you've delivered is when it goes to the secretary to type. And in the process of typing, proofreading, and so on, the secretaries and the clerks were using that to extort money from litigants. And they will always give the excuse that, oh, my lord has not finished proofreading the judgment. And when I discovered this, I felt the only solution would be to learn how to type. But how to go about it? One of my sons then was in secondary school, and he was the first person to teach me the lazy brown fox jumps over something or other. If you've learned typing, you'll remember that sentence. So I started with that. And that was also the time when we had dial-up internet connection. So with my little learning, I used to try to send emails and things. But by the time I've composed the email, the line would have cut off. And we have to start again. And thereafter, I was now introduced to a software that teaches typing. It's called Mavis Beacon Teaches Typing. So that was my next teacher. And gradually, I developed a little proficiency, and I was able to start typing my judgments myself. And what that did for me was that whenever I delivered a judgment in court, I was able to tell the litigants that the judgment was ready for collection, or it will be ready by the close of business if I noticed a few corrections. So that was my first introduction to technology. Secondly, with that software, I learned what is now called hallucination in AI language. And that is, I got this dictation software where you read into the machine and it transcribes on your computer. But it's made really for dictation and not working as you go along. So whenever you pause, and perhaps you are thinking, you are trying to gather your thoughts, as you are breathing into the machine, it is interpreting it as a scramble of letters. So you have to edit. That also improved my editing skills, and I learned to navigate a lot of things on the computer. So these are some of the early introductions for me to technology and appreciating the value of technology in efficiency in the work that we do. Now, these experiences that is now rising through the ranks have afforded me the rare privilege of observing our justice system from every level of adjudication. They have taught me one enduring lesson. The quality of justice delivered by the courts depends significantly on the quality of advocacy presented before them. Every carefully prepared brief, every well-researched submission, and every professionally conducted case contribute to the administration of justice. The bench and the bar remain indispensable partners in that constitutional enterprise. Today, that partnership faces a defining moment. Technology has moved beyond improving efficiency. Artificial intelligence now assists legal research and drafting. Digital platforms are reshaping commerce and dispute resolution. Electronic evidence has become commonplace, and emerging technologies such as blockchain and smart contracts are creating entirely new legal questions. Judges and lawyers are increasingly confronted with issues that previous generations could scarcely have imagined. This reality presents a fundamental question. What becomes of justice in an age where information is limitless, intelligence is increasingly artificial, and decisions are ever more influenced by algorithms? That is the question I invite us to consider today, not from the standpoint of technological fascination, but from the perspective of constitutional responsibility. As the program for this Law Week necessarily requires that I speak within a limited time frame, the remarks I shall deliver this morning are an abridged version of a more comprehensive keynote paper. The full text, in which these issues are examined in greater detail with fuller analysis and comparative perspectives, will be made available to delegates for further reflection. In these remarks, I shall first suggest that the era of technological disruption has given way to an era of responsible stewardship. I shall then examine the implications of artificial intelligence for legal reasoning, precedent, and professional practice. Consider the evolving responsibilities of both lawyers and judges within an increasingly digital constitutional order. Reflect on how technology can be harnessed to democratize access to justice, and conclude by considering Nigeria's opportunity to build a justice system that is technologically innovative, constitutionally faithful, and anchored in the enduring values of the rule of law. Taken together, these reflections lead to a central proposition. While technology may transform the methods by which justice is administered, it can never displace the constitutional principles or human values that give justice its legitimacy. End of the disruption era. For more than 2 decades, conversations about technology and the legal profession have been dominated by one word: disruption. We were told that artificial intelligence would replace lawyers, algorithms would eclipse legal reasoning, and digital platforms would fundamentally transform legal practice. Experience has now given us a clearer perspective. Technology has unquestionably changed how law is practiced. Legal research is faster. Electronic filing and digital case management have improved court administration. Artificial intelligence now assists lawyers in reviewing documents, identifying authorities, and organizing information with remarkable speed. Virtual proceedings have expanded access to justice and demonstrated that technology can coexist with procedural fairness. Yet, despite these remarkable developments, one truth remains unchanged. Technology is transforming the way legal services are rendered and courts operate, but it does not alter the fundamental values upon which the administration of justice rests. The administration of justice remains at its core a profoundly human enterprise grounded in constitutional values, informed by reason, and directed towards fairness. The purpose of the legal profession remains the peaceful resolution of disputes, the protection of rights, the preservation of constitutional order, and the advancement of justice. Technology derives its legitimacy only when it serves those purposes. The real question, therefore, is no longer whether technology will transform legal practice. It already has, as we have already been told this morning. The question is whether the legal profession will lead that transformation or simply react to it. Throughout history, lawyers have served as custodians of constitutional democracy. Every generation has responded to new social and technological realities while ensuring that every new instrument of power remains subject to the discipline of law. Our generation bears the same responsibility. Accordingly, we must avoid both extremes. We must neither reject innovation because it is unfamiliar, nor embrace it merely because it is technologically sophisticated. Every innovation must satisfy the same constitutional standards that govern every exercise of power. It must be lawful, transparent, accountable, and above all, fair. These principles continue to guide the digital transformation of the Nigerian judiciary. Across the Federation, electronic filing, virtual proceedings, and digital case management are improving efficiency and expanding access to justice, while the National Judicial Institute and the National Judicial Council continue to strengthen judicial capacity for the digital age. Technology is not an end in itself. It is an instrument through which justice may be delivered more efficiently, more transparently, and more accessibly. Its true measure is the extent to which it strengthens public confidence in the administration of justice. Artificial intelligence, predictive justice, and the future of precedent. Among all emerging technologies, artificial intelligence raises some of the most significant jurisprudential questions of our time. Across the world, AI systems can now analyze thousands of judicial decisions, identify patterns, and predict the likely outcome of disputes. These capabilities promise greater certainty for lawyers, businesses, and litigants. Yet, they also require careful constitutional reflection. Prediction has always existed within the common law. Lawyers routinely assess the likely outcome of cases by studying precedent. The doctrine of stare decisis promotes consistency and certainty. But the common law has never confused consistency with rigidity. Judges remain free to distinguish earlier authorities, develop legal principles, and respond to changing circumstances. That is how the law has evolved over centuries. Artificial intelligence can recognize patterns with remarkable speed. It can assist lawyers in evaluating litigation risks and identifying likely outcomes. What it cannot do is perform the judicial function itself. It cannot determine whether justice requires departure from established precedent, weigh competing constitutional values, or exercise the judicial conscience that lies at the heart of adjudication. Artificial intelligence may therefore predict what courts have done in the past. It cannot determine what justice requires in the particular case before the court. Equally important, algorithms are not inherently neutral. They reflect the data upon which they are trained and may reproduce historical bias while appearing mathematically objective. As artificial intelligence increasingly enters commercial transactions, financial services, and eventually litigation, our legal profession must develop principled standards governing algorithmic evidence, transparency, and accountability. At the same time, AI offers genuine opportunities. If predictive tools encourage informed negotiation, mediation, and arbitration, thereby resolving disputes more efficiently, they should be welcomed. The purpose of the law is not to maximize litigation, but to secure the fair, peaceful, and timely resolution of disputes. Our challenge, therefore, is not whether predictive technologies should exist. It is to ensure that they remain firmly anchored in constitutional principle, professional ethics, and meaningful judicial oversight. The technology-enabled lawyer. These developments naturally raise an important question: what becomes of the lawyer in the age of artificial intelligence? The real question is not whether AI will replace lawyers. It is whether lawyers will develop the knowledge, adaptability, and professional discipline necessary to remain indispensable. Law has never been distinguished simply by access to information. Information has always been abundant. What distinguishes the lawyer is judgment, the ability to interpret facts, balance competing principles, anticipate consequences, and exercise ethical responsibility. Those qualities become even more valuable in an age of intelligent machines. Throughout my years on the bench, I have observed that the quality of judicial outcomes depends significantly on the quality of legal advocacy. Technology now forms part of that process. Used responsibly, it enables lawyers to devote more time to strategic thinking and deeper legal analysis. Used carelessly, it risks undermining professional standards. Accordingly, today's lawyer requires two complementary forms of competence. The first is legal competence. The second is technological competence. Not merely familiarity with software, but sufficient understanding of technologies such as artificial intelligence, blockchain, digital evidence, and cybersecurity to advise clients responsibly and present informed arguments before the court. Artificial intelligence is a powerful professional assistant. It is not a substitute for professional judgment. Recent experience has demonstrated the danger of relying uncritically on AI-generated material. Lawyers have been sanctioned after relying on authorities that were entirely fabricated by artificial intelligence, a phenomenon which I referred to earlier, now commonly described as AI hallucination, where an AI system generates information that appears plausible but is in fact false. These incidents were not failures of technology alone, they were failures of professional judgment. The ethical duties owed to clients and to the courts remain unchanged. Lawyers must understand the tools they use, verify every authority they cite, and remain personally responsible for every submission they make. Artificial intelligence can improve efficiency, but it cannot diminish professional responsibility. The future of legal practice belongs not to those who possess the most advanced technology, but to those who combine technological capability with intellectual discipline, ethical integrity, and sound legal judgment. Those same qualities will become equally indispensable for the judiciary itself. Judges, no less than lawyers, must be equipped to evaluate increasingly sophisticated technologies while remaining faithful to the constitutional values that define the judicial office. It is to that equally important responsibility that I now turn. The judge in the digital constitutional order. If technology is reshaping the responsibilities of the advocate, it is equally reshaping the responsibilities of the judge. Every significant technological development eventually arrives in a courtroom where it must be examined, not simply through the lens of innovation, but through the enduring requirements of legality, fairness, and constitutionalism. Today's courts are increasingly confronted with disputes involving artificial intelligence, digital assets, cybercrime, blockchain transactions, electronic evidence, and synthetic media. These are no longer matters of academic interest, they are practical questions of adjudication. For that reason, judicial education must continue to evolve. Judges must possess sufficient technological literacy to understand how digital systems operate, critically evaluate expert evidence, and ensure that technological tools remain consistent with constitutional guarantees. The National Judicial Institute has already taken important steps in this direction, and those efforts deserve continued support. At the same time, the judiciary must continue to embrace responsible innovation. Electronic filing, digital case management, and virtual proceedings are helping to make our courts more efficient and more accessible. Justice Faji has given us the example of the Federal High Court, and it's happening gradually across the Federation. Yet, one principle must remain beyond debate. Technology is an instrument of justice. It can never become its substitute. Judicial decision-making involves far more than applying rules to facts. It requires the interpretation of constitutional values, the assessment of credibility, the balancing of competing rights, and the exercise of judicial conscience. Those responsibilities cannot be delegated to algorithms. Our Constitution provides a clear guide. Section 36 guarantees the right to fair hearing. Every party must be able to understand, test, and challenge the evidence and reasoning upon which judicial decisions are based. That guarantee is difficult to reconcile with opaque artificial intelligence systems whose reasoning cannot readily be explained. And I believe this has been described as the black box, where there's a conclusion, but you don't know all that AI used to get to that decision. Similarly, as synthetic evidence becomes increasingly sophisticated, courts will continue to confront important questions concerning authenticity, reliability, and accountability. Artificial intelligence may assist courts in organizing information and improving efficiency. It cannot assume constitutional responsibility for determining rights and obligations. That responsibility remains and must always remain with human judges accountable under the law. Democratizing justice, harnessing technology to expand access. While technology presents new constitutional challenges, it also offers one of the greatest opportunities to expand access to justice. For many Nigerians, the greatest obstacle is not the complexity of the law, but the difficulty of accessing the justice system itself. Distance, delay, administrative inefficiency, and the cost of litigation continue to deny many citizens meaningful access to justice. Thoughtfully deployed technology can help remove those barriers. Digital systems simplify court administration, improve transparency, reduce delay, and enable judges and lawyers to focus more on resolving disputes rather than managing cumbersome processes. The Nigerian judiciary has embraced this vision through sustained digital reform. Electronic filing, virtual proceedings, and digital case management have become increasingly common across our courts. These developments have been supported by legislative reforms, including the recognition of electronic evidence and the enactment of laws governing cybercrime and modern criminal procedure. As Chief Justice of Nigeria, I have consistently maintained that judicial reform must extend beyond procedural innovation to embrace institutional transformation. Technology should not merely replicate existing administrative processes in electronic form. It should improve those processes by making them more transparent, more efficient, and more responsive to the needs of court users. It is in furtherance of that vision that the Supreme Court is now concluding arrangements for the formal implementation of the National Case Management System, NCMS. This represents one of the most significant institutional reforms ever undertaken by our apex court. Beyond its technological sophistication, the MCMS will fundamentally improve the management of appeals by providing an integrated digital platform through which cases may be monitored from commencement to final determination. It will enhance registry administration, strengthen case tracking, facilitate better scheduling, improve data integrity, and provide a more transparent framework for judicial administration. Closely aligned with this initiative is the forthcoming unveiling of the Supreme Court's mandatory upload of electronic copies of processes, record of appeal, and other matters, Practice Directions 2026. These practice directions will require the electronic upload of court processes and records in addition to the existing filing requirements, thereby ensuring that the court progressively develops a secure digital repository of its proceedings while preserving the integrity of the judicial process. This reform is expected to enhance efficiency, reduce avoidable delays associated with physical documentation, improve access to case materials by the justices of the court, and contribute significantly to the timely determination of appeals. These initiatives to strengthening the administration of justice, they are intended to improve the experience of litigants, enhance the productivity of legal practitioners, support judicial officers in the discharge of their constitutional responsibilities, and ultimately reinforce public confidence in the judiciary. As we modernize, however, we must ensure that technology expands rather than restricts access to justice. Digital transformation must never create new forms of exclusion for those with limited access to technology or limited digital literacy. Nigeria has every reason to approach this future with confidence. We possess a vibrant legal profession, an innovative judiciary, and a growing technology ecosystem. Our objective is not to imitate other jurisdictions, but to develop solutions that reflect our own constitutional values and institutional realities. Technology must serve Nigeria's justice system, not the other way around. Nigeria's movement, building Africa's leading digital justice system. Nigeria stands at an important moment in its legal history. We possess the largest legal profession in Africa, one of the continent's most active judicial systems, and an increasingly dynamic technology sector. The opportunity before us is to bring these strengths together in building a justice system that is efficient, innovative, and firmly grounded in constitutional values. The judiciary cannot achieve this alone. It requires partnership across the entire legal community. To the Nigerian Bar Association, I encourage continued investment in technological competence as an essential aspect of professional competence. To judicial officers, I encourage sustained judicial education so that our courts remain equipped to determine increasingly complex technological disputes. To our universities and the Council of Legal Education, I urge that technological literacy become an integral part of legal education. To policymakers, I encourage the development of a coherent national framework for the responsible governance of legal technology and artificial intelligence. Finally, to our innovators, I offer this challenge: build technologies for Nigeria, solutions that understand our laws, our procedures, and our constitutional traditions. If each institution plays its part, I am confident that Nigeria can become a continental leader in technology-enabled justice. A charge to the next generation. Permit me to conclude my remarks by speaking directly to the younger members of our profession. You are entering legal practice at a remarkable moment in history. Entire fields of practice are emerging around artificial intelligence, digital assets, cybersecurity, data governance, and technologies that continue to evolve. This should not be viewed with apprehension, but with confidence. The lawyers of the future will still require a sound grounding in constitutional law, commercial law, criminal law, evidence, and legal procedure. Those foundations remain indispensable. But doctrinal knowledge alone will no longer be enough. Professional excellence will increasingly require intellectual adaptability, technological literacy, and a commitment to lifelong learning. Above all, never lose the habit of asking difficult questions. Artificial intelligence can generate answers with astonishing speed. It cannot determine whether the question itself has been properly framed. It cannot replace curiosity, independent reasoning, or critical judgment. Throughout my judicial career, I have found that the finest lawyers are not always those who know the most. They are those who think the most deeply. Never allow technology to diminish your sense of professional purpose. The law remains a profession of service. Every client advised, every brief prepared, and every argument advanced contributes to the administration of justice. The lawyers who will lead the future will not simply be those who possess the most advanced technology. They will be those who combine technological competence with integrity, intellectual discipline, and an unwavering commitment to justice. Conclusion. Technology as the instrument, justice as the purpose. Ladies and gentlemen, permit me to conclude by returning to the question with which I began. What becomes of justice when information is abundant, intelligence is artificial, and algorithms increasingly influence decision-making? The answer, I believe, is now clear. Technology does not diminish the importance of justice. Rather, it makes our constitutional responsibilities even greater. The era of debating whether technology belongs in legal practice is behind us. Technology is already part of our professional reality. The future does not belong to those who choose between law and technology. It belongs to those who ensure that technological innovation is governed by the rule of law, while harnessing its potential to make justice more accessible, more efficient, and more responsive to the needs of the people it serves. The courts have never existed merely to resolve disputes. They exist to preserve public confidence that justice is possible. That confidence rests not upon sophisticated technology, but on the integrity of our institutions, the independence of our judges, and the professionalism of our lawyers. No algorithm can replace those values. Technology is one of humanity's greatest achievements, but every instrument derives its worth from the purpose it serves. In the administration of justice, technology must always remain the instrument. Justice must always remain the purpose. Let us therefore commit ourselves to embracing innovation with wisdom, remaining faithful to the Constitution, strengthening the rule of law, and ensuring that every technological advance serves the fair, effective, and accessible administration of justice. I thank you for your kind attention and wish you a fruitful and intellectually rewarding week. God bless the Nigerian Bar Association. God bless the Nigerian Judiciary. God bless the Federal Republic of Nigeria. Thank you very much. Thank you.